There's long been debate about whether or not the federal government is given too much power. And it's true that the federal government has been slowly gaining more power over the course of history. People are becoming more and more anxious about an all-too-powerful federal government meddling with their private lives. Let's take a look at one of the many Supreme Court cases that gave the federal government more power to regulate individual American citizens. The 1942 court case on interstate commerce, Wickard versus Filburn. This is Roscoe C. Filburn. He's the owner of a small farm in Montgomery County, Ohio. He's got cows and chickens, and with those come milk and eggs. And in the winter, he plants wheat and harvests them the coming July. He uses this wheat to make money, to feed his livestock, to eat, and for the next winter's seeding. In 1941, Filburn harvested a total of roughly 462 bushels of wheat from his 23 acres of farmland. In July 1940, however, Filburn was notified 3 times before his 1941 planting of wheat that he was only allowed to produce a total of 223 bushels of wheat. He was limited to 11.1 acres, yielding 20.1 bushels of wheat per acre by the Agricultural Adjustment Act of 1938. Producing over 223 bushels of wheat would result in a monetary penalty of 49 cents per bushel, and thus, Filburn, with an excess of 239 bushels, was fined $117.11. So you may ask then, what is the Agricultural Adjustment Act? Well, during FDR's New Deal program, the Agricultural Adjustment Act was created to restore the economy and provide relief to the Great Depression. Specifically, the federal government wanted to reduce surpluses and increase demand in the economy. One of the ways they tried to prevent surpluses was to pay farmers not to plant on a part of their land. In Filburn's case, the act sought to regulate the amount of wheat moving in interstate commerce, applying limits on states and individual farms to prevent large fluctuations in wheat prices. Filburn, using his excess wheat only for personal uses, believed that his wheat did not have an impact on interstate commerce, so he did not want to pay the penalty. And so we have the big question: does the government have the right, by the Commerce Clause, to regulate activity within a state? First, let's take a look at Filburn's argument. Filburn had filed a lawsuit against the Secretary of Agriculture, Claude R. Wickard, arguing that the government has no right to restrict crop production of individuals, especially since his usage of excess wheat has no impact on the market itself. His other argument was that the Agricultural Adjustment Act is unconstitutional, violating the Fifth Amendment, which states that the federal government does not have the right to deprive anyone of life, liberty, or property without due process of law. The Supreme Court, however, believed that Filburn's personal use of excess wheat, although never touching the market, does have influence on the wheat market price. Their opinion, written and delivered by Justice Robert H. Jackson, was that because Filburn has excess wheat at his disposal, his need to purchase from the market is lowered, and thus the excess wheat decreases demand in the market, which consequently increases wheat prices. Their claim was that regulation of interstate commerce is dependent on individual supply. Additionally, the Supreme Court also believed Filburn's Fifth Amendment argument was not that his quota was unfair, but that the Fifth Amendment excuses him from penalties for planting and disposing wheat, which they did not agree with. Their key point was that the Agricultural Adjustment Act was an agreement between the government and the farmer. The farmer agrees to produce less while receiving a return that is higher than the profit their wheat would normally bring. If they happen to produce too much, they can turn in their wheat or store it for next year's quota. If they do anything else with the wheat, they are subject to the penalty. Finally, the Supreme Court emphasizes how production and commerce are two very different things, highlighting that the federal government is not violating states' right to regulate production because the federal government is regulating commerce. The final decision was that the Agricultural Adjustment Act is constitutional, stating that yes, the federal government does have the power to regulate both interstate and intrastate activities as long as it has impact on interstate commerce. Although Filburn's excess wheat may be trivial under the light of the larger market, the case is precedent for future cases. The Supreme Court ruled considering what might happen if every farmer had Filburn's situation. If everybody produced excess wheat, then the impact on the market would be substantial. The final Supreme Court ruling of Wickard v. Filburn established that the federal government has much greater power under the Commerce Clause than ever before. It changed what aspects of interstate commerce the government was allowed to have power over and was the start of an era of growing federal power.